But here we are, second Wednesday morning break of 2022. I'm Patricia Scott. I'm in our Lansing office, and I tend to be the moderator of this this segment if you ever have attended before. So if you haven't, welcome. If this is your first time. Today we have Cliff Hammond, who we've had many times before. So thank you, Cliff, for joining us. He's up there in the corner of my screen. It looks like he's literally sitting in a corner.
Great.
Cliff is a labor and employment attorney that works in our Foster Swift's Lansing and Southfield offices. He practices mostly in employment law and development and litigation in relation to employment and labor issues. Cliff is going to talk to us today about all things COVID, mostly in relation to vaccine and testing, which is questions that are on many of our minds these days. So with that, thanks, Cliff, again. We're just going to go ahead and get started. I think the first question for everybody is, what in the world is the status of the Osha and CMS vaccine mandates?
Great. So right now we're in limbo at the Supreme Court, but technically OSHA's standard is in full force and effect. So if you're wondering whether OSHA has been stayed by the Supreme Court, the answer is no. And so to go back a little bit and talk about this for people who don't completely understand or know the history of what happens. The president, way back in September, decided that he was going to issue an executive order on a number of things, including healthcare, and then it expanded into other private industries as time went along. And he issued a number of executive orders about vaccines and testing. And they included really federal contractors, which we're not going to get into today, and then large employers with 100 employees or more. That's the OSHA standard that ultimately came out. OSHA took the president's executive order and devised some plans and devised some rules and then promulgated those back in November. He also put out originally nursing home rules, but then he expanded it to people who get Medicare and Medicaid generally, and they came up with something called CMS, Centers for Medicaid and Medicare Services rules for healthcare, a separate line of cases that if you have 100 employees or less and you receive that kind of money, you've got to do some things with vaccines. So you have these two rules. They've meandered through different courts. They've been stopped. They've said you can't do that as a federal government. They've continued on because they got lifted. And right now, both of those are in full force and effect. But because of the delays that the court system had, they didn't go into effect right when they were supposed to. So as we sit here today, the Supreme Court last Friday has heard arguments on appeal of whether the court, the highest court in the land, should stop those for right now, put an injunction back on. But they haven't done so yet. So let's just talk about the two rules. OSHA has a rule that says if you've got 100 employees or more, you have to go out and you've got to put some policies and plans together about vaccines and testing. And we'll get a little bit more into that. But right now, that first day, the first time you were supposed to be in compliance under OSHA's rule was Monday. Monday was a day to get your policy in place, to have a vaccine policy. It was supposed to be the first day that they would enforce the idea that you need to have a list and you need to have records that shows everybody who's vaccinated and everybody who's not vaccinated. You need to see if there's an exemption out there for somebody who has a religious exemption. They can't take it because of a bona fide religious reason, or a medical exemption, a legitimate medical exemption, without getting into all the details of how you determine those. That's what you're supposed to have. So everybody's supposed to be tested, you're supposed to be listed on a list. You're supposed to have records of all this. And if you're not vaccinated, you're supposed to have a mask on at all times. Then come next month, February 9th, that's when you have to start testing. That's when OSHA says we're going to start giving citations if you're not fully vaccinated and you're still working because you have an exemption, or even let's say you don't have an exemption. Let's just say you just don't want to take one. Then you have to take a test, within every 7 days just to keep coming to work. Generally, there are some exceptions. So that's what's going on right now from OSHA. We'll talk about that in a second. May or may not apply to you, depending on where your workforce is and where you're at. CMS, the other one we talked about, now it actually has two stages going on. They have a phase 1 and phase 2. CMS for healthcare is really unique because it does not have the testing option. Testing doesn't exist. There's no test. There's just get yourself vaccinated. And the first stage is the 27th of this month, January 27th. And then the second phase is the 28th. That means you've at least got to get your first dose by the end of this month, the 27th. And you got to have your full dosage going on, your initial dosage by the 28th. So you got to have a policy in place. You've got a lot of, requirements, but testing's not an option. That's where the religious and medical exemptions could save you if you're an individual who doesn't want to take it, but you can't just say, I don't want to do it. You actually have to have an exemption. So that's where we're at right now. Where we're at right now is OSHA is saying we're going full force ahead until the court stops us. CMS is doing the same. These are two government agencies and they enforce it. We'll talk a little bit more about it, but that's generally where those two rules are right now in the court system.
And just so that everybody's clear, can you define OSHA and CMS for us?
Yeah, Occupational Safety and Health Administration. And if you've ever dealt with safety or somebody having a problem in the workplace, or you have a nuisance in the workplace, they'll come in and investigate, what is going on, whether you have a safe workplace or not for injuries. Centers for Medicaid and Medicare Services is the agency that oversees a lot of the Medicaid and Medicare provisions and the federal granting. Now, the way that they work is CMS enforces its rules through your state health department. They come in and do citations. OSHA generally is a federal agency that actually handles like most of the states, not all, but most states. Michigan's not one of those, however. We are different than OSHA.
Okay, because we have my OSHA.
And that's the next step. So people always tell me, well, OSHA's here. And I always tell them, you're right, 100% correct. OSHA has a rule. OSHA's applied it. OSHA is the one that goes in effect. So if you have a company that has multiple locations, OSHA will apply. But here in Michigan, that's not the case. What happened was when OSHA was started, states had the right to make their own state level safety administration. And we did. We opted out of the federal rule, and we decided to create what they call MyOSHA. Some people call it MeOSHA. I think that's kind of a silly way to say it. So I just say MyOSHA. And the long story short is we have our own rules. Now, the standard was you can go ahead and have your own agency, but you have to be at least as strict or stricter than the rules at OSHA. So what MyOSHA has been saying since day one when this came out in November is, look, we're not trying to get into this game. We're not really trying to push too hard on this. But we're going to do what we have to do because we don't want to have our certification as a state agency revoked, which can happen if you don't follow. And they've threatened that from OSHA. So they said, look, we're going to do whatever they say, but nothing more. So if it gets stayed, they're not going to do it. If the Supreme Court says it stayed. So what they have to do is they have to adopt policies that are the same. That doesn't mean it has to go into effect the same timetable. So that's why when I started off talking about what are the rules on the 10th, actually, Michigan's not 10%, but it appears from a notice that if you go to the MyOSHA website, you'll see right at the top of their website, they say, look, we're monitoring this situation closely. We are looking at the 24th of January because they understand Supreme Court's going to take a little time to figure out what they want to do. So we're not jumping in the game quite yet. We haven't 100% adopted this. But we're looking at the 24th of January to really say, hey, employers, get yourself right. So what they've done, they said, I think you should go look at the OSHA guidance on how to cooperate and how to be bound by this rule. So I would strongly suggest that you do what MyOSHA tells you to do, which is between now and January 24th, if you have 100 or more employees, or you're not sure how to count 100 employees, go to the OSHA website. And I'm going to give you the website right now. We can, give it to you afterwards, supply this afterwards. It's OSHA.gov/coronavirus/ETS2/FAQS. And it is a very detailed, long list of questions. It's got 12 sections. It talks about how do I count if I have 100 employees? It talks about what do I have to do? Who do I have to kick out if they're positive? What if somebody gets a positive test, but they think it's false and they get a negative test? How do I bring them back in? Who are the people who are exempt? Who are the people who don't have to test? how do we do things such as pay people? Is there a limit on how much we have to pay people? They actually did a very good job of essentially walking you through without having to look at this 400 plus page ridiculous rule that they came up with. You can go into this and get some pretty quick and easy questions. There's still some blanks that you got to go back in and review the rule. But that's where we're at. So the bottom line is we are seeing the state of Michigan and Osha say we're watching the Supreme Court and we're probably going to implement it. But to the extent we implement it, we're just going to follow whatever OSHA's done. OSHA's already put out a number of very good clarifiers for us. So the question is going to be, who's vaccinated? I just saw a question go by, say, what's fully vaccinated? Right now, fully vaccinated means you've got two, right? The first two doses of your Pfizer and your Moderna, or the one J&J. It doesn't include booster shots yet. All right. So that's where we're at. CDC and OSHA may change that, but that's where we're at now. They're recommending it. They're getting stronger and closer. But right now, that's what this rule is saying. But, and this is important, for record keeping purposes, you're supposed to continue to keep records of all the vaccinations. And if someone gets a booster shot, you're supposed to keep that record too, because if you were to be audited, somebody makes a complaint to OSHA, they come in, they look at your records. They're going to want to see, okay, where are those records at? And give me a sheet of who's vaccinated, not vaccinated, and it should include all their vaccinations. So we're going to probably get to the point where if you need a booster, that needs to be there, but it's not there yet. So right now, fully vaccinated is just the two initial shots. In fact, we'll get to this in a second, but there's a pay component to allowing employees to get vaccinated. They want you to encourage vaccination very strongly, and they're asking you to put a policy together. It's very good because OSHA actually has put together a sample policy. It's very good policy. It's a solid, strong policy that hits most of the points they want you to have. They want you to have that accessible to all your employees. So you can literally go online, you can find their policy, and you can fill it in about who do we submit the cards to, what are the dates, what's the general parameters of what we're doing, but it has blanks for those. So it actually is a good skeleton for you to start with, to put that policy together and get it out to employees so they understand how they can take time off to go get vaccinated. What do you do if somebody isn't fully vaccinated? Things of that nature.
Okay, Cliff, thank you. That was a lot of information. So I think if we can try to take it down a little bit more bite size and back up just a second and ask a couple of the questions. How much do we have to pay, or do we have to pay employees when they are off?
You might have to. All right. So it all depends. In this area, it gets really complicated. So I just want to back up even further than that. Just remember, there's this plan. It may apply, it may not apply. So the first thing you have to do is figure out, am I 100 employees or not? So I would strongly recommend, if you don't know if you're under this rule or not, figure that out. If you're under this rule, you've got to make a list and ask your employees for proof of vaccination. You'll get that from this website of exactly how you ask and what is acceptable proof of vaccination, even if they've lost their vaccination card. Okay. Then you can say, okay, I've got the vaccination. I've made my list. I've got that compiled. I know what fully vaccinated is. I've got a policy in place. It talks about education. It talks all those things. Now, the next thing that you want to do is, like you said, know whether or not you have to pay people for certain things, because there's two things that are going to happen. You're going to have an employee who is going to have to be vaccinated. And then you're going to have those people who aren't vaccinated that are going to have to be tested weekly. Most people. Talk a little bit about the exceptions in a minute. So the question always comes up, do I have to pay people to get tested? Well, let's back up. We don't want to answer that. The first question is, do you have to pay people to go get the vaccine? Now, that's the first question you should ask, not whether you have to get tested. It's the vaccine. And the answer is generally yes. They want you at OSHA, and OSHA will follow suit. They're requiring you to encourage employees to get the vaccine. And by encouraging, they mean give them some money. So you should pay up to a cap of 4 hours, a minimum of 4 hours of pay. And people say, well, I'll just let them use their sick time. No, you cannot do that. You have to actually pay for the primary, and this is the key, primary doses. So right now, it appears to me the primary dose, based on everything that I've read, is your first two shots. right? Not your booster, but your first 2 shots. You got to give somebody that much time. And they say, well, a lot of people say, well, I'll just have them do it on the weekend. I'll just have them do them after work. And it's very clear on there. You can't try to get people to take it on the weekend. You have to allow them to do it during the workday and get vaccinated if they haven't been fully vaccinated yet. So if a person volunteers voluntarily to go on their own time or go on a Saturday, you're not required to pay. But if a person wants to get a vaccine and they say, I'm going to get a vaccine, and you're supposed to tell them to go get a vaccine, you're supposed to encourage them to take it, you are supposed to pay them not from their bank account, but out of your pocket as an employer for that vaccination, period. So that's supposed to be above anything else they're entitled to. Again, you don't have to pay them to do it in their own time. Then the next question comes down to, well, what if I have side effects? What if I don't feel good afterwards? Well, the rules look at it and they say it's pretty much reasonable that you should give a person up to 2 days of paid time because of side effects. Okay. And you can put a reasonable cap. You can pay them more if you want, right? But you have to at least give them up to 2 days. And then what OSHA did is said, all right, I'm not going to make you pay out of your pocket for all that time. If the person has sick time, you can make them use the sick time for how much they have. You can't make them go into a negative balance. You can't make them borrow from the future that they haven't accumulated it yet. But if I've got 2 days worth of time and I don't feel good for 2 days because of my shot, then I can make you use your sick time. What I can't make you do, though, if you have sick and personal time, say vacation, I can't make you use your vacation time. So let's just say you only have a day of sick time. I can't make you use the 5 weeks of vacation time. I have to just simply let you use that. And anything else above it, I have to pay as an employer. If you have PTO, like a combined bank, you can go ahead and make them use that PTO, exhaust their PTO. But again, importantly, you can't make them borrow and you can't make them go into debt for recovery. So you've got, I'm going out for the vaccine, that's on the employer. I have side effects, that may be something you can force them to use, the employee to utilize their sick time because they're sick, like you would any other illness. So then now after we get done with that, because that's the urgent part of this rule. The urgent part of the rule is, hey, we want to encourage people to get vaccines. We want you to pay them. Here's how we want you to do that. That's the money, okay? Now the question is, let's just say I have Johnny and Jim and they don't want to take the vaccine. They, for whatever reason, they have a religious reason or just don't want to take it, right? And they have to get tested. They get to get tested every week when they're coming in, or else we can't have them in the workplace. We exclude them. So they go out and get tested. Now, nothing in this rule requires you to pay them. Nothing. This rule says specifically, we're not requiring you to pay them for the time to go get tested. That's it. But not so fast. Because it actually says, well, there may be some other laws. Now they know what the other laws are. They're federal laws. And our friends at the EEOC and Department of Labor have all chimed in on all these great things. And just to make it easy, they've decided, like everything in this rule, they say, do this. And then some other agency comes out and says, well, I know they told you to do this, but beware of that. And you're like, what's that? Why didn't you tell us about that? There's always a hidden problem. There is a Department of Labor guidance out there that is saying, do I have to pay for time off to get tested? And they said, beware. If it's job necessary and required and essentially part of your job is what you do, and I'm making you do it as part of your job, then maybe it is compensable. And they give an example of a grocery store clerk who has interaction with the public. And if I'm making you get a test, then that seems to be pretty related to my job because I'm out there interacting with people and I'm trying to make people safe. So you should pay for the time I take to go get tested, even if it's on my own time, not during regular work hours. If you're making the person.
Cliff, you just got muted.
There we go. How's that?
Better.
Okay. Yeah. So if I have somebody come into work and I test that work before the job starts, then I obviously have to be paid. If you're making me come in, you're testing me right there, I would take the conservative approach based on everything I've read, said, and seen so far that you definitely have to do it. If the person just has to do it and they're not interacting with the public and you just have to do it on your own free time whenever you can, there's an argument you might not have to pay. It's not definitive. My conservative guidance is it makes sense to pay an employee if you're going to require them to do so. It puts us in a very difficult position. And why is that? This isn't unintended. All right. The intended consequence here is you can have a policy that allows employees to follow the guidance from Osha, to have everybody come to work and be vaccinated, or you can have a policy that says you can either be vaccinated or tested. But if I put the hammer down on employers and say, and by the way, you got to pay for that testing, not directly in the rule, but I'm nudging you from the other side that you might get a class action lawsuit from all your employees later on down the road, and it's not quite clear, and some judge might find against you because it's still a little fuzzy. That might make people think twice about allowing people to come to work if I've got to pay every single week for 100 plus employees for that hour driving to and from the test. And how are you calculating the time? And how are you managing that time? It's a hidden cost, if you will, of this rule that is very frustrating for most people. Now, what are employers doing? Most employers are not going to pay for that time. All right. I already know what's going to happen. I know a lot of places are just going to say, I'm not paying for it. If you don't want to take the vaccine, I want you to come to work. I'm not making you come to me, but I don't want to pay for it. That's fine. You can do that, but just understand that there's a risk because right now the guidance should be coming out. We should have more guidance coming soon. We just don't have it yet. They're so busy at the court, I guess. So you have different agencies and different laws interpreting this rule. And it's been the problem since day one. And here's the reason why. Imagine you have an employee. Employee A says, I'm not coming to work with this vaccine because it's against my religion. And I have sincerely held religious belief that I can't take this vaccine, period. And it's legitimate. They just don't want to do it. And you say, that's fine, go get tested. And they go, well, I'm not going to get tested either. You say, what do you mean you're not going to get tested? Well, I guess you can't work. And you say, oh, not so fast now. The reason why I'm not going to get tested is because my sincerely held religious belief says that test violates my religious belief. And you go, well, I don't care. I've read all these rules. I've read all these FAQs, and I don't have to let you in if you don't get tested. And they go, well, wait a minute. There is something in here that says, but maybe you might have to do an accommodation for that person. And then you go to the EEOC, they refer you to the EEOC's guidance, and the EEOC says, well, you got to make sure that you don't discriminate against people because of their sincerely held religious belief. And then they don't really talk about specifically this specific issue, which is what this is all about. You would think maybe they would address this issue. Instead, they're like, well, figure it out on your own. But what they do generally is they say, there are some things you can do. Potentially, you can make them wear a mask, stay 6 feet away, put some physical barriers in. So at the end of the day, so what you're saying is, I don't have to test, I don't have to get vaccinated, and I can just pretend like it's, April of 2020 again, and we can just go back with this person because they say they have a sincerely held religious belief. And the answer is potentially, depending on the facts and circumstances. It's an individualized assessment. There could be some people who say they can't do either, and you've got to look at it. And that's a hard one. And I can't say broad brush that it's going to be a lot of people doing that, but it's a potential consequence, and there are gray areas in this rule. So for the most part, the rule is pretty simple. Get vaccinated, pay for them to get vaccinated, pay for them to recover, pay for them if, it's going to be an on-site during the work hour testing, potentially pay if it's on their own time, depending on the nature of the job and the nature of the testing required. But there could be accommodation requirements if you can. You may not be able to accommodate the person depending on your workplace. But as with everything, the devil's in the details. So you have to be careful with those who have religious accommodations. And that goes to another question for another situation, which is, how do we accommodate? How do we go through that process? And that is something that we could probably take a long time. And I'm dealing with that a ton. People put in accommodations all the time. There's actually a case that just came out in the Eastern District Court here in Michigan. A guy had his case denied, his request for a religious accommodation. He had an employer who was going to enforce its policy, and he wasn't going to be able to come in. And the judge basically said, I'm not going to give you an injunction If you get fired, you get fired. You can always get money. That's what you sue for. And that's the way it goes. So maybe you're right. Maybe you're wrong. We'll find out later on, maybe 6 months, 8 months, 2 years down the road. But, some places are taking a tough line on some religious exemptions. We can talk about that in a little bit. But what OSHA has said is that if you're going to give people a religious exemption, if you're going to give people a reason not to do it, you have to keep some sort of record of that interaction, right? And as an employer, you don't have to give people the ability to continue to work in the place. You can say you can have a testing requirement anyway. So most people who have a religious exemption are just going to get tested and it's going to be fine. But there's always that gray area. So those are the 3 areas that I see for pay. If a person's off, remember we used to have the FFCRA, Families First Coronavirus Relief Act, that used to pay people a bunch of money. That's gone. It's out the window. They make it very clear that's not their goal. They're not trying to get people extra money. They can use their own sick time. They can use their own time. If they run out of time, then it's unpaid. There are exceptions to this thing. If somebody doesn't want to get tested, but they work 100% remotely, then they don't need to be tested and they don't need to have a vaccine. If you work exclusively outdoors, and I mean exclusively outdoors, maybe you go inside like a shed to go to the bathroom or to get a cup of coffee and out maybe once a day for 5 minutes or less, yeah, you can probably go ahead and get away with, because they're not going to be part of this rule. They don't have to be vaccinated. They don't have to have the testing, but you still have to keep a record of the person. So there are exceptions to the rule. I strongly recommend you go to that coronavirus FAQ. It helps you walk through your employees. And then if you have more questions, obviously you can contact us or look at it a little more clearly, but it does give you a roadmap, but you don't have to pay for all that time off. Okay, so that's important.
Okay, thank you for all that. And I want to comment, I do see the questions are being submitted and we'll get to those at the end. For the sake of time, I do want to get through the Cliff's initial points here, and then at the end, because we've already gone over, but it's obviously an important topic, I want to get through Cliff's, and then we'll go to the questions, and that way if people need to drop off, they can. And just to remind everybody, this is recorded, so if you do have to drop off but you want to come back and see what Cliff had to say, you can do that. So Cliff, we've talked a lot about pay, but then there's this big vague question about how much time do they have to stay off. The CDC, quite frankly, they've been getting a lot of heat, right? Is it 5 days? Is it 10 days? Is it symptoms? Is it not symptoms? Do we need a negative test? How much time do they have to stay off?
Oh, very simple. It's very easy. I think that the important part is, if you think about this is exactly what the CDC has said. They've said, as far as time off, all you got to remember is, right?
You just got muted. I'm sorry, we didn't hear the answer.
Oh, sorry, I did that on purpose. Sorry about that. No, it's because it's not clear, because it's the most unclear guidance of all time. It's ridiculous. So they reduced the time. Remember now, let's go back for a second. The CDC gives guidance and recommendations. Okay, this is not like what we had in 2020 running into last year, where we had concrete state of Michigan rules. Here's what you've got to do. What we have now is we've got guidance from the CDC. They're doing the best they can based on whatever. I don't know what it is down there, but they're doing their best to try to put guidance that's as clear as possible. They've reduced the time period for most people for the quarantining and the isolation. I strongly recommend you go to the CDC's website and you take a look. They have a flow chart. They actually have a flow chart that's pretty good. And it talks about, look, if you're fully vaccinated in the last 6 months, here's sort of what happens with your quarantining if you're in close contact. If you're not, if you're fully vaccinated in the last, and you got your booster shot, here's what you do. If you're fully vaccinated and it's been a long time and you haven't got your booster, you fall in with the unvaccinated people, okay, for quarantining. And it talks about symptoms and testing. And generally what happens is, let's just say I've got, I've got COVID, I test positive, but I'm asymptomatic. They've got a flow chart for that. If I've got symptoms, when do I start to look at it? Again, it's normally going to be, and there's always these differences. There are people who are asymptomatic. There are people that are symptomatic. There are normal people, and then there are people who have very severe illnesses. And then there are people who are immunocompromised. We could go through all these machinations and variables for a very long time. But I think what we need to do is just step back for a second. Remember, it's usually going to be 5 days, right? That's your period. It's going to be 5 days. Day 0 is the day that you start having symptoms. That's generally what it is, right? And then the next day you count 1, 2, 3, 4, 5. Everything's starting getting better. You're resolving your symptoms. You're fever free. You can generally go back to work and just wear a mask for another 5 days. That's generally what they're trying to do. They're trying to just get a very simple 5-day plan. But there are exceptions. In fact, basically the whole thing talks about symptoms being the start of the test. And then there's like a caveat that says, but if you want to, you don't make people because tests might not be available. If you want to, towards the end of that 5-day period, if a person tests and they test positive again, then they need to stay out for the full 10 days. And you're like, well, wait a minute. I thought we weren't supposed to ask for tests because tests could be positive for 90 days or longer. So there are some variables in here that you have to look at on a case-by-case scenario. So if you asked me and told me specifically, okay, what kind of person are we talking about, vaccinated, unvaccinated? And have they been exposed? Are they having symptoms? How are they immunocompromised? And has it been going on for a long time? Is it very severe? All right, we have to ask those questions first. From that, we can start flowing generally down. Most people are going to fall into the 5-day gap or they don't have to quarantine. But as far as the CDC's guidance, I don't think it's very difficult as long as you know the facts. You just got to know, who am I dealing with? What are the symptoms? And when did the symptoms first start? And did they get a positive test? Okay. You go from quarantining because you're in close contact. All right. And maybe you have, and once you have symptoms, then you may go down to isolation. Then you go to isolate and say, how long am I going to isolate? And usually it's going to be 5 days, right? Usually 5 days, come back to work, put a mask on. That's generally what they're trying to get to. Very simple. Whether that's right or wrong, we don't know. They were thinking about requiring some additional maybe testing before you come back to work. But again, where do you get a test from? Number one is going to be a bigger problem. You want to wait in a long line. And number two, does that really help us? Because you may have a positive even if you're not contagious anymore. And they found that you're really not that contagious, according to the CDC, not me, I don't know, that contagious after a few days after your symptoms. So what they're basically saying is once you get some symptoms, you got a few days, get back to work. And go ahead.
Is COVID FMLA qualified leave?
It could be or it may not be. And that's where a lot of people are getting in trouble sometimes. And it's a bigger issue than people sometimes understand. If I test positive for COVID, but I have no symptoms, the question is it FMLA qualified leave? It may or may not be. Most of the time, if I have a health issue that I had to get tested for, I tested positive, and I have to stay out of work, that's generally going to be FMLA qualified. Generally, it would be. But if I am in close contact with somebody, I'm unvaccinated, and I have to quarantine because of that, but I don't really have much symptoms from that, it may not be. It may not be FMLA qualified. So it comes down to the definition of FMLA. Look at if you're an HR professional, you have to look at it. Is this something, did I have to go to the doctor? Do I have a health issue for myself? Am I out because of my own, or am I caring for somebody with COVID? We go through the same analysis. Most of the time, yes, it's going to be. But there could be an exceptional circumstance where it's not. And if you just designate time as FMLA because it's related to COVID, here's the problem. If you exhaust the person's FMLA and then they have another FMLA qualified absence down the road, and you go, oh no, you're out of FMLA. Now you just violated the FMLA because you took time that should not have been computed as FMLA absences. And you now have an absence that should otherwise have been counted as FMLA. And what happens? If you knock out their insurance, and if you fire them, you could have a problem. All right. So it's a tricky road. So I would make sure you go through the same analysis you always do for FMLA qualified absences.
Okay, so how about the employee that keeps taking time off and keeps going out on leave, COVID related? Can you terminate that employee?
No, don't. You're going to get yourself in trouble. You're going to have a retaliation claim, the interference claim with FMLA potentially, as well as Michigan has a statute that allows you to stay out for the season the required time. So don't get mad if it's legitimate and the person's out. Just deal with it. It's frustrating, but it is what it is.
But I think that key phrase is if it's legitimate. So we all know people. We all have employees. We all know people. Every other day they think they have COVID, right? So they're going off for this. So they've got to take some time off. Oh, I think I was exposed. I mean, so do you have the right to determine if it's legitimate, or just flat out don't fire them for it?
I have a hard time telling people, I mean, if you have a person who is saying I was exposed, that could be happening. I mean, look, it's pretty darn high chance that they may have been exposed. Now, the question is, are they allowed to be out? Then you have to look at the rules as far as the CDC as, are they a person that should be quarantined or not, depending on their status as vaccinated or unvaccinated. So if a person is protected because the CDC says that kind of person should be out, that's one thing. If they say they have symptoms, I would have a very difficult time getting involved. And disciplining the person says I'm asymptomatic, but I was around somebody and I'm fully vaccinated. We look at the CDC rules as of that second, because it could change today, and see whether or not they have the right to be out. And if they don't have a right, to be out, or it's not recommended they be out, then that person might not be, that person would not be protected. So you can just use your normal disciplinary process. But I would be very careful before I issue a discipline to somebody, because it is protected under Michigan statute, and the CDC's guidance have been in here. You'll have an Osha claim, you'll have a retaliation claim, you'll have a Michigan claim, a disability, an associated disability, all those fun things that we get from an agency or an attorney. Just be careful before you stomp on somebody because they're out every Friday. Oh, I think I was exposed. Yeah. I need my 4 hour. Yeah. If it continues to happen, then we can look into it. And there's some ways that we can advise it. Generally, I just tell people be careful. But if it's an abuser, it's clear it's an abuse and it's every Friday, we need to take a look at it a little bit closer. Ask more questions.
Okay, I'm going to go into the questions in the chat at this point. The first question that we have here, we talked about the accommodation for testing and vaccination. Is there also an accommodation for face coverings?
Well, it's the same accommodation we've been talking about since about 1.5 years. If a person can't wear a face covering because they have a medical condition, you have to go with their doctor. It's individual, right? I don't know what their job site looks like. I don't know where they're at, but you do have to give them a reasonable accommodation, all right, if one is available. So if we all work together in a huddled mass and you can't wear a mask and it's not safe, I can exclude you from work. If it's just simply going to be, you're not vaccinated, you're in my workplace, you can't wear a mask, even if I give you a reasonable one, that's fine. I'll say to you, what if I give you a moon suit? All right. What if I give you a full moon suit so it doesn't touch your face? There are some, we go on, there's a thing called JANA, Ask JANA, which has got a job accommodation network that they actually have put together from the government. Helps you go through different types of issues, give reasonable accommodations. Or you could ask the person, look, here's your job description, here's what we do. Ask your doctor for a reasonable accommodation. What can we work with you? Go back and forth in reasonable accommodation. Ask them, can we stagger your shift? Can we stagger where you work in your workplace? Can we do something else to give you an accommodation? There are people that may not have to wear a mask if they can just come in a little earlier, run into their workspace, close the door, keep it completely concealed from everybody else. Maybe that's an accommodation that works for your workplace. Not every workplace can do it. It's a wide open area. So it is potentially something that we have to look at on a case-by-case basis.
Okay. Will those who've had COVID ever be considered vaccinated due to natural immunity?
Well, no, probably not by this group. They're pretty clear that if you have COVID, you've had COVID, but not the vaccine. So that's just the way it is. It doesn't matter what anybody says. There's all this, I've read all this stuff from people who are very clear that, natural immunity is just as good as or better or super or whatever it might be. But our fine friends here at the CDC and our friends at OSHA don't share that at this point. So now what there is exceptions. So let's just say I'm supposed to be fully vaccinated. Well, there's an exception medically. If I've had COVID, I had to get some sort of treatment and they recommend that I don't get the second vaccine or the first shot or whatever it might be for 90 days because I had this treatment. Maybe I had the monoclonal antibodies, or I've had some other type of treatment where they say, don't get that yet, you have to wait. Now, that would be a medical reason, exemption of why you don't have to do it. You just got to wear a mask, but that would be an extension. But as far as right now, just having COVID itself isn't going to be good enough right now. That may change. I'm not saying it won't, but our friends right now over here at the government have made it pretty clear they don't care about COVID. They care about vaccination. That's it. I don't know if that's going to change. And I don't think it's going to change, to be completely honest with you, but it might, depending on what happens with this Omicron, that could be a game changer. Maybe they say, no, that is enough if you can show proof of it. But
okay. For the next question, I think you already answered it, and I'm not sure what time these came in, but if maybe just a quick summary, it's how and where is the religious exemption applied and what documentation is required if it's granted or rejected?
Well, the religious,
answer that one.
Yeah, religious exemption really comes in more with the healthcare one. It's very important there because you don't have the testing option. It's you're vaccinated or you're out kind of situation, unless you can get that medical or religious exemption. And the EEOC's put some guidance out there on this, and it's really good. If you go to the EEOC, they've got a coronavirus EEOC website, FAQ, that really goes through a lot of this. Section K actually is where it's at, if you have the time to look at it. And they basically say, look, it's about your belief. So for instance, let's just say, you read everything, that the Pope has said, hey, it's okay to get the vaccine. But let's just say you have an individual Catholic that says, my personal belief is because of the use in the development and the testing and the production of these, multiple virus or vaccines, the use of stem cells is against my personal belief, and that precludes me from being able to use it. And if that's a sincerely held religious belief that precludes you from doing it, generally speaking, that's probably something that's acceptable. Now, that's it. And the EEOC has said you need to ask the person for the reason in writing. You need to have them supply a statement or some sort of documentation to support it. But when a person gives a legitimate, non-discriminatory, or not a legitimate statement, you're supposed to take it on its face. You're not supposed to debate unless there's something egregious about it. And what you can't do, this is the weird thing about it, at first what you would say is there's tons of cases out there on the flu shots. A lot of hospitals used to have flu shot requirements. A lot of healthcare settings used to have flu shot requirements. And the battles would go on this religious exemption all the time. So this isn't new, okay? This whole exemptions request from private employers. And they would say it's a health and safety measure. They would say, I have a religious exemption. And they will look at it and say, look, is it legitimate, number one? Is it based on a religious objection or just your moral kind of general value? And people say, well, that's not fair. Well, that's the way it is because it's literally religious. Now, you can be non-religious if it's like a religion, all right? It can be a very rare situation, but you need some sort of documentation. They say, let's just say I got the flu shot last week, and this week I decided I'm not going to get the COVID shot. Well, the EEOC has said you can change your religion. I mean, you can be more adept. You can get into it more, do more research, and have a change of mind. So just because they've had a inconsistent past doesn't mean that the current, situation and statement isn't true. So that makes it more difficult for people. At a time, I've seen multiple employers have gone out and said, hey, look, I just want you to know, here's the 15 different, common medicines that are tested the exact same way using stem cells. You say you can't do it, but do you take these pills? And they say, yeah, that's really neither here nor there. So you're supposed to take it unless it's, clearly, inconsistent with what they're doing right now. I mean, if it's in your face, and it's going to be hard to prove that. Get your documentation from them, get their opinion. If you have a question, a legitimate question about something doesn't add up here, and it's, not just, hey, in the past you had a problem with nothing and now you have a problem with this, then you go ahead and ask them that question. But then you say, okay, that's step one. Step two is, can you accommodate it? And the accommodation for a religious objection is not as robust as a medical exemption. So if it's going to cause some sort of undue hardship on you, you might be able to deny that. You might be able to deny that request. Flipping to the medical exemption, that's really where it gets to it. Because if you look at it, there's really only 2 medical exemptions that we've seen. That's if you've had some sort of interaction in the past, the stuff that's in these vaccines, so you've had a reaction to them, or you've had a severe allergic reaction to vaccines in general. Other than that, a lot of people are putting in requests saying, hey, I want a medical exemption because I'm very immunocompromised. In that situation, you got to push back a little bit. You got to ask the doctor, listen, the CDC has indicated, and you can go right to the CDC's website. They'll tell you what the interdictions are. They'll say here are some things that we believe are inappropriate, but it'll say, we believe that it's appropriate. Why is it that you've indicated that this is a reason the person needs a medical exemption when the CDC has indicated that it's not listed as one? Please provide information as to why. And in the CMS rule, they're very clear about it. They want you to have proof that you've gone through that process and have documentation. You can't just have Susie come up and say, hey, I want a medical exemption. Oh, okay. No, you got to have that paperwork to show that you've actually looked through it.
Moving on for sake of time, the next question relates to reactions to the vaccine. And if you're a company that has mandated the vaccine and your employee then has a severe reaction, can the company be held liable?
Well, that's a difficult question to answer because we don't have cases on that. Now, my first reaction is, can you be held liable? It all depends on who gives it. Is the company providing the vaccine? If the company's actually got the vaccine being issued on site by it, directed by it, could be workers' compensation, potentially. I'm not saying it is. That could claim that could try to be made, right? It's something that they could try to make it as it's on site being issued by that company. Otherwise, following directives of the government, implementing a policy and having a vaccine that's been authorized by the federal government doesn't appear to be something that you would be held liable, except I could see potentially, I'm not saying there is, we don't know, we're just saying potentially, I put in a request for an exemption for a medical reason, I deny it and say you have to go get it under the CMS rule, for instance, and you do, could that person say, you forced me to do it afterwards? And of course, my argument is going to say, I didn't force you to do anything. You're a grown adult. You could get tested if you wanted to. You could have taken that option. You could have.
To be clear though, Cliff, this question was related to mandating vaccines in the workplace. So yes, it is a mandate. That was the question.
Well, let's go back to mandate. Nobody's mandating anybody go get a vaccine.
So employers can mandate though. They can mandate vaccines, can't they?
The question is, if I get a vaccine because I'm mandating a vaccine, and what I'm trying to argue here is what the argument in court would be is, I'm not mandating you get a vaccine. I am saying that if you want to continue to come into the workplace and get paid, you have to do it. But that's your choice. So whether a court would say that a byproduct of your decision to continue to work in an at-will employment situation, most people are at will, whether you chose to get that or not was your decision. And you still had the ability when you went down to get the vaccine to make that final call to say, you know what? I don't want to take this vaccine. I don't want to work there. Now, I can't tell you whether or not there's liability because I haven't seen any cases of liability yet. I haven't seen one.
Okay.
I that there's not going to be liability. It would be hard to get over that. Most likely you wouldn't be held liable because the person still has a choice. It's not like, this isn't conscription into the army. All right. This is, I want to work for someplace and the place says I have to do something in order to work there. And then I chose to do it to work there. It's not, it's still, you had some choice in this matter. You could have decided not to take it. Again, we'll see what the courts say. I haven't seen any courts say you're going to be liable for it. I don't see much reason to do it unless, of course, again, you're doing it at the workplace. They might make a work comp claim. It'll probably be denied, go through the courts. But who knows what the case law is going to say. But generally speaking, I don't believe there's going to be any liability. I've seen nobody say that. I've seen nothing in any court say that. So I don't see it. It could change, but I probably not.
Okay. going back to the testing requirements for a minute, if someone has recently had the virus, do you still have to test them weekly, knowing that they could be positive for up to 90 days?
Yes.
Okay.
Or they have to submit a test, not you.
They have to be tested as part of the policy.
Yeah. And again, I mean, that could change, right? We could get guidance that changes that from OSHA. But for right now, what I've seen from them is yes. Again, if it's a false positive, there are ways to go back and get the testing. But yeah, I mean, I don't see an exemption for that right now. It could change. Everything changes on this stuff, as we all know.
Well, and then somebody would fall back on the CDC rules and the 5-day rule, and if they're symptom-free at that point, and they're long 5 days beyond when they first had symptoms, and that doesn't mean they have to be out just because they're testing positive, right? Okay, so last question. All the others I think have already been answered, and is COVID still considered a recordable illness by OSHA/MyOSHA if it meets the record ability criteria and cannot be determined to have been contracted outside of work?
Yes, the same rules haven't been changed. There's been no variance in that. And again, that could change at any time. All right, so we're waiting to see. I mean, at some point in time, that'll probably change, right? It'll probably change, but right now it's the same.
Okay. All right. Well, that was a lot of information. Thank you very much. We know that we went over the time by quite a bit, but that was a lot of useful information. So thank you everybody for attending. And like I said, this was recorded if you need to rewatch it or you want to pass it on to somebody. We'll be back on February 9th with Stefania Gismondi, who's going to talk about something entirely different than COVID, thank goodness. Because I think many of us are over it, right? It's autonomous vehicles and liability related to those. So tune in next month for that. And with that, have a great rest of your day.